Your compliance manual, navigating a regulated industry. The objectives in this lesson is that by the end of the lesson, you should be able to identify your responsibilities under SEC Rule 2064-7, understand what your firm must maintain, describe why a compliance manual is needed, compare and contrast RIA and other models, and consider whether to manage or to outsource this oversight that your firm will require. Now, the Advisors Act of 1940 did say that SEC registered investment advisor firms have to adopt and implement written supervisory and compliance policies. And they must designate a chief compliance officer to administer its compliance policies and procedures. Well, if a firm of one, I guess that means you're it, which takes away from your client-facing time. So you do need to take this seriously and add this into your thoughts of how you're building your ideal practice. So the registration decisions that you need to think about is that there are quite a few RIAs, in fact the majority of them, choose not to manage assets. That lowers the compliance requirements that they need to follow. And you may think about outsourcing it, a lot of CFPs do, or you may really love that part of the business. And if you do, then thinking about who will handle that for you, whether it's you or somebody else, is an important first step. You also may consider, if you're going to manage money, that you offer money management as something in your list of services. So an RIA will have to decide if they're going to be state registered, and if some states require written policies, some have a little bit of different requirements, so you really need to check state by state. But all investment advisor firms are required to establish, maintain, and enforce written policies and procedures to prevent misuse of information. So there's a requirement to some extent either way, so it's really best practices to have something, whether your state is less restrictive or not. Now, the states that have requirements similar to SEC regulations for federally registered investment advisors have policies for supervision and compliance. And when you join a firm, your compliance oversight is provided for you, and you pay a fee for that, or it's withheld from your earnings. And if you go the RIA model, where you're responsible for this, then you must either create your own compliance manual, an officer to provide the oversight, or you need to outsource this. So you have to think about if you want to be affiliated with somebody who provides it for you, or you want to manage your own practice. Because if you decide that you do not wish to be affiliated, then the compliance requirement is going to be your responsibility. And it's a good business practice. The regulators will ask to see that within an examination of your firm. So it's one of the first things you want to do before you open the door for clients. It needs to cover your compliance information, and we're going to get into the details of what kinds of things need to be in there. But again, the smaller size firms without any conflicting business interests could probably go with a less complex supervisory and compliance policy than one that has multiple businesses under their umbrella. So your chief compliance officer has to be knowledgeable and competent, of course, in what they're enforcing, and they have to be empowered to enforce these things. The officer is disclosed in your manual, And then, depending on whether your firm is SEC registered or state registered, depends on where in your paperwork that you provide your clients, that Form ADV, where it's disclosed. So you would file an annual amendment to Schedule 1 of your ADV that includes all of the assets under management, because the amount of assets do influence how you have to register. The SEC examines your financial condition during the application process, so be aware of that. Most states want an RIA to have a net worth of at least $35,000 if you're managing client funds, and $10,000 if you do not. And if you don't meet that, you have to post a bond. So be aware of some of the financial requirements as well. Now, your manual needs to prevent the violation of our requirements under the Investors Act of 1940. It incorporates your fiduciary responsibilities, your regulatory obligations, and should it detect any violations have occurred, have procedures for correcting them. It addresses the risks. It talks about your portfolio management processes that are consistent with client objectives. It reveals your trading processes, your research processes. If you have any soft dollar arrangements with somebody else where you provide exchange services, you need to disclose that. If there's any personal securities trading of your supervised person, there'll be disclosures, your account statements, your advertising and marketing, your fee schedule, how you safeguard your client assets, and a business continuity plan. So be aware, they want to know what happens to your firm and your clients if something happens to you. So the very first way to begin this is to perform a risk analysis. And this is so important because it's one of the first things regulators will ask to see if they come in and evaluate your firm. Now, you can purchase compliance manuals, and they do have something off the shelf, but you can't assume that they're already ready for you. You're going to have to customize them for your firm according to your firm's specific information. Or you can hire an outside firm to do this compliance for you. Now, all employees need to have a copy or access to a copy of this. They have to acknowledge that they've seen it. You have to notify them if there's been any changes to it. And you have to maintain those records for at least 5 years. Now, other records that would be required in case you're audited are all your financial and accounting records, your receipts, your disbursements, any kind of journals, any income and expense account ledgers, your checkbook, your bank account statements, your advisory business bills and financial statements, any orders that trades that clients have submitted, or any trade confirmations for them. They'll want documentation about the proxy votes for any stock that they hold, their written requests for withdrawals of their money and their documented deposits, any written correspondence to or from your client that especially discusses anything regarding their investments. Those things are particularly reviewed. Any advertising and newsletters, any records related to the code of ethics, your documentation of your written disclosure that it's been delivered, and anything that you've documented in the course of your annual reviews. So you can see it's quite detailed. There's a lot of things to keep track of. Some of this may sound familiar if you're already working in a firm, things that you save your correspondence, you know that you have to submit a written request for deposits or money, something goes in. Now you understand why. Somebody is collecting those and keeping those and managing those for that firm that you belong to. Now, if you decide that this sounds exciting and you do want to register as an RIA, you do have to have a Series 65. If you're going to manage investments, and depending on the size of the firm, will determine whether you register with SEC or you register with a state. One of the things that you also need to know that even though you don't have to, if you register with the SEC and you don't have to register with the state, you still have to give them a notice. So there's requirements that you're going to have to follow on an annual basis to make sure that it's documented that you are going to be handling money. Now, once you register get your Series 65, you create an account with FINRA. You're going to get an identification number. You're going to file your Form ADV and your form that talks about your outside business activities. That's like your U4 forms. If you're already a practitioner, those are familiar to you. And then once your application is approved, the firm may engage in business. Cybersecurity guidelines have gotten to be a very important topic. And you want to do a periodic assessment of where you hold this information. You want to make sure that there are security processes in place from both internal and external threats, and what the impact of a breach would be on your firm and what you would do. So you want to create a strategy to prevent threats and detect them if they've happened. You want to implement some written policies and procedures and training. You want to make sure that your electronics are encrypted. And that would include things also for be careful the way you communicate with clients. You don't want to send personal information over the internet where they can be stolen if the client does not have an encrypted computer. Just because you have one doesn't mean they do. So it's unfortunately not just if, but when, but you need to demonstrate that you have as much safeguarding as you can in place. So in summary, you've learned about why many RIAs choose not to manage investments, the compliance steps and requirements for an RIA, and the SEC's cybersecurity requirements. Thank you.